Hi, Jenny.
Hi, Sarah.
Thank you for joining me today for a little discussion on a topic that I think a lot of your clients and the community that you work with especially will be very interested to hear about. You work here at Nauman Smith with our business and employment law practice group, as well as our nonprofit practice group. And so the topic for our discussion today is employee classification. And I know it's a very timely topic as a lot of people adjusted. Maybe they were working more than one job during the pandemic or taking on these side gigs. Employers were looking at their infrastructure and how their people were classified. And so I know that this is a very timely topic. So why don't you go ahead and jump right into it and tell us what is it that we need to know about employee classification?
Thanks. So today I'm very excited to share some tips, especially for small businesses and startups. Like you said, with today's legal landscape, it's really important for small businesses and startups to think about how they're distinguishing between employees and independent contractors. How you classify your workers is really important for various reasons, especially the benefits that workers are going to be eligible for, what types of taxes need to be withheld. And misclassifying employees as independent contractors can have major financial implications for your new business. You could end up owing back taxes to the IRS or state unemployment. You could end up facing major fines for unpaid overtime or owing back wages. And that's something you definitely want to avoid as a smaller business while you're trying to get off the ground.
Yeah.
You don't want to face those big fines.
Nope. So how do businesses determine how their people should be categorized? Are there tests? Are there questions they have to ask? What is all of this based on?
So at the beginning of forming a new worker relationship, it's exciting as a small business. Maybe you're hiring your first worker, but it can also be pretty overwhelming because every government agency has their own tests. There's also all these common law tests out there. But many of the tests are kind of rooted in this concept of who has the control in the relationship. And the test I'd like to talk about is the test developed by the IRS, and it's called the Right to Control test. And essentially, under this test, independent contractors are the ones who control how and when the work is performed. So the IRS test looks at three areas of control within the relationship: behavioral, financial, and then they look at the relationship of the parties as a whole. So under behavioral, you would consider things like, does the business or independent contractor control when and where the work is done? Who determines what tools and equipment are used? Who owns the tools and equipment? And who's purchasing supplies? For financial, you would be thinking about things like, has the worker made a significant investment into the work? Are expenses being reimbursed? And is the worker incurring a profit or loss from the project? If the worker was incurring a profit or loss, that would make it more likely to be an independent contractor relationship.
I imagine that behavioral one, the when and where, really came into play, especially as a lot of parents and other caretakers found themselves juggling multiple roles while schools were closed or schedules were just shifted all over the place. I know even in situations for myself and people I know, it wasn't a question of, can you complete the work? It was, when are you going to complete it? And how do we have to relax those rules or come to a compromise, within a business arrangement to make sure that everyone's still, getting what they need out of the role and the job. So how has that changed? Are there any new assessments now? I know you talked about the one that you just listed with the three characteristics, but is there anything new on the horizon for business owners?
Well, like I mentioned, how there's different tests depending on the government agency that you're looking at. One agency that has been reevaluating their tests is the Department of Labor, and they control the test that applies for the Fair Labor Standards Act. And that's the law that applies for things like minimum wage and overtime. And that's particularly relevant, like you said, about like remote work arrangements. And their test that applies right now was adopted from the previous administration, and it was called an economic reality test. And I won't go through all of the factors, but there was kind of two important factors to consider in the analysis of whether a worker was an employee or an independent contractor. And similar to the IRS test that I talked about, the analysis was controlled by this right to control factor and the opportunity for profit and loss, like I mentioned earlier. But this recent past fall in 2022, the Department of Labor proposed its new rule that would completely shift this analysis. And it primarily was brought up by the new administration because of the gig economy. And like you said, how these new work arrangements are taking place in 2023. And this new test has 6 factors, but ultimately the question under the new test is whether, as a matter of economic reality, the worker is economically dependent on the employer for work, making it an employee, or is in business for themselves, making it an independent contractor.
Interesting. So that makes me think that a lot of people will have questions about their unique situation and whether they are on that contractor side or on the business owner side. So I know that you are available. Our team is available. There's resources out there. So where do you want to direct people who might watch this and have questions, or what is your, final words or thoughts on this topic?
I guess as a final thought, I would say that this is a constantly developing and moving topic. The new proposed rule from the Department of Labor has not taken effect yet, still in public comment period. But it's something that you need to keep your eye on. And if you're making a new employee arrangement or you have existing ones, you need to be looking at the language and consulting with your attorneys, or give us a call and we'll help you look through that to make sure you're compliant with the current rule, but also keeping an eye on prospective developments to make sure you're prepared for the future.
Very good. Well, thank you so much, Jenny. I enjoy talking about this with you. You're certainly very knowledgeable, and it's topics that I don't often get to dive into. So I will make sure that when we post this video, your contact information and Nauman Smith's contact information is available to people. And we will have another discussion, I'm sure, on this topic and others in the future. So thank you.
Thanks.